Most people think once police connect your name to a robbery case, especially an aggravated robbery, your life is basically over. But in Texas, being around the wrong people at the wrong time can sometimes get you accused of a felony you never planned, participated in, or even knew was about to happen. And I recently handled a case that shows exactly how dangerous these assumptions can be. My name is Joseph Reese. I'm a criminal defense lawyer here in Houston, Texas, and today I want to walk you through a real grand jury case involving allegations of robbery, aggravated robbery, and accomplice liability. This was a case where my client was accused of being connected to a very serious felony offense, even though from day one he maintained that he was never part of the robbery itself. And what makes this story important is how we were able to challenge the case before indictment and ultimately convince the grand jury not to move forward. Because lots of people don't realize this, but some of the biggest battles in felony cases happen before the grand jury even gets involved. So here's what happened. My client was driving around Baytown with a friend of his. His buddy recognized someone that had previously sold him some bogus drugs. He calmly told my client to pull into the gas station. My client's friend gets out of the car and goes inside to confront the guy. He ends up pulling a gun and taking some jewelry off of him at gunpoint. He then jumps back in the car and my client, not knowing what to do or what just happened, drives them away from the scene. My client's freaking out, wondering what the heck just happened. At some point, prosecutors started building the theory that my client wasn't just there, but that he was actually an accomplice, or as we call it in Texas, a party to the robbery. In Texas, prosecutors do not always have to prove that you were the person holding the weapon or directly confronting someone. They can try to argue that you solicited, encouraged, directed, aided, or attempted to aid the crime happening in some way. And that's where cases become very dangerous very quickly. The government claimed that my client and his friend had a premeditated plan to rob this person at gunpoint. My client was there, he even had a gun on him, and he drove off after what happened. But the government can't make assumptions. They have to prove that my client and his friend had a coordinated plan for this to happen. Once we started digging into the evidence ourselves, the story became very different. When my client was arrested and agreed to speak to the detectives, he adamantly denied having any idea that any of this was going to happen. When they spoke to his friend, even he said that all of this was his idea and that my client had no idea what was about to happen. And this became the biggest issue in the case. Was it enough that my client was there and fled the scene with the primary actor? Thanks to Texas case law, the answer is no. Scott v. State established that merely being present at the scene of a crime and fleeing from that scene with the primary actor alone is not enough to establish that that person is a party to the crime. Because being present is not the same thing as participating. Knowing someone is not the same thing as agreeing to commit a felony with them. And in accomplice or party cases, prosecutors still have to prove intent. They have to show that someone intentionally promoted or assisted the crime. The government's theory that this was a planned and coordinated robbery completely fell apart once we obtained the surveillance footage from the gas station and sifted through the lengthy custodial interrogations. Now, this case was heading to a grand jury, which meant we were running out of time before a potential indictment. And if someone gets indicted for aggravated robbery in Texas, the consequences are life-changing. Through the grand jury packet, we wanted to introduce them to the real version of our client, a young man with no criminal history, college educated, and a youth basketball coach that was hanging out with the wrong person. And we wanted to educate the grand jury on what Texas requires to actually be a party to the offense. After reviewing everything, the grand jury chose to no-bill the case. In other words, they determined there was not enough probable cause for this case to continue on. Instead of us having to convince the prosecutors that they would have a hard time proving this to a jury beyond a reasonable doubt, the grand jury killed the case right then and there. No 5 to 99-year exposure, no stress and cost of a full-blown jury trial, swift justice. And this is exactly why the early stages of a felony case matter so much. Don't go with the public defender and then hire someone months into a case. Get an aggressive lawyer involved ASAP. A lot of people think there's nothing they can do once they find out they're under investigation for a felony. That's simply not true. In many cases, the grand jury stage is one of the most important opportunities to challenge the accusations before the process gets too far along. If you or someone you know is under investigation for robbery, aggravated robbery, or any other felony offense in Texas, don't wait until an indictment happens before taking the situation seriously. I'm Joseph Reese, criminal defense lawyer here in Houston, Texas, and if your future's on the line, my office is ready to help you fight back before the system makes assumptions that could change your life forever.